The decision by the High Court judges Teresia Madeka, George Odunga, Joel Ngugi, Jairus Nga, and Chacha Mwita continues to elicit mixed reactions across the political divide.
Constitutional and constitution change process promoted by the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that we've given in our judgment.
In a process being pushed by President Uhuru Kenyatta and the opposition leader Raila Odinga, the country's Attorney General Paul Kihara and the country's Solicitor General Kennedy Ogeto have already filed documents to appeal the High Court's decision on Monday. The duo are challenging the decision of the 5 judgment on claims that it actually subverts the will of the Kenyans.
That the IEBC did not have this quorum at the time it made the consequential decisions related to the Constitutional Amendment Bill. It therefore follows that all the decisions so made by the IEBC in relation to the proposed constitutional amendment and in particular to the Constitutional Amendment Bill were invalid, null and void for lack of quorum.
Members of the county assemblies are the latest political class to join the bandwagon in bashing the ruling by the High Court.
We as members of the county assemblies are very disappointed, dismayed and dissatisfied with the recent judgment on BBI as it set a very treacherous and hopeless path in this country. By holding that some sections of the Constitution cannot be amended, whether by popular or parliamentary initiative, or what they generally term as eternity clauses, the judges boldly and without any solid analysis took away the sovereign powers of the people enshrined in Article 1, Section 1.
The members of the assembly in a media briefing claims that the due legal process was actually followed in carrying out public participation across the country.
And they seem to insinuate that any public participation that is not translated to Swahili, to mother tongue, to Braille and or the other languages is not public participation enough. We haven't seen any public participation that has gone through that in the past.
But as the proponents vowed to challenge the decision at the Court of Appeal, the opponents in the process have, however, on the other hand, vowed to also challenge the decision up to the Supreme Court of Kenya.
Definitely, one way or the other, it will have to end to the Supreme Court. Because now that they have preferred to appeal, should they win, we as the petitioners definitely are going to appeal to the Supreme Court. And should they lose, I do not see them just settling and agreeing that the Court of Appeal is the final arbiter. They will still go to the Supreme Court. But either way, the BBI process will have been dealt a big blow. So if you're looking at a judgment delivered by 5 brains, you need a bigger number of brains. So we would expect at least 7. So I do not see the judges accepting that they are going to depart from the 21 issue holding. And they could agree with 1 or 2, but then not entirely.
It's a do or die political game for President Uhuru Kenyatta who wants to leave a unity legacy. But this might not be a walk in the park following the hefty legal challenges ahead of him. Reporting for Ebru TV, I'm Jeff Haemba.